If you've ever lived in a neighborhood with a homeowners association, you know it's a world full of rules, right? Rules about your lawn, your fence, maybe even the color of your front door. But what happens when you think the very people enforcing those rules are the ones breaking them? Well, we're about to dive into that. So, this is the exact spot one homeowner found himself in. He looked at his HOA's rulebook, he looked at what they were doing, and he thought, wait a minute, something doesn't add up here. So he decided to challenge them. And that decision kicked off a journey deep into the world of bylaws, legal arguments, and the surprising power of just a few words. All right, let's meet our players. On one side, you've got John Ashley, a homeowner. And on the other, the Rancho Reyes Second Community Association, his HOA. Back in 2019, Mr. Ashley filed a formal petition against them, starting a legal dispute where, believe it or not, everything hinged on how you read a couple of crucial sentences in the rulebook. Mr. Ashley's entire complaint really boiled down to this one claim, that for 2 years straight, the big annual community meetings were totally invalid. Why? Well, his reason was simple. He said they didn't have what's legally known as a quorum. Think of a quorum as the minimum attendance required to play the game. If you don't have enough people, any votes, any decisions, they're basically null and void. But here's the twist. Mr. Ashley wasn't saying not enough homeowners showed up. No, he was arguing that not enough board members were in the room. So to really get what's going on, we have to go right to the source, the HOA's own bylaws. And look, this isn't just some friendly neighborhood guide. As we're about to see, this thing is a legally binding contract. That's right. In the eyes of the court, these bylaws are a serious contract. When you buy a home in that community, you are agreeing to its terms. And what that means is that the specific language, the exact words they use, that's everything. Which brings us to the two sentences at the absolute heart of this whole fight. Okay, so check this out. The bylaws had two completely different rules for what makes a quorum. The first one, for general meetings of all homeowner members, said you need 10% of the votes. Easy enough, right? But the second rule, for meetings of just the board of directors, said you need a majority of the directors themselves to be there. And that is the million-dollar question. Mr. Ashley believed that for a general meeting to be valid, you had to satisfy both conditions. You needed 10% of homeowners and a majority of the board of directors in the room. The HOA, on the other hand, was like, whoa, no way. Those are two separate rules for two totally different kinds of meetings. So this disagreement, this clash over what the text actually means, it led to a full-blown legal showdown. Let's break down exactly what each side was arguing. Okay, so Mr. Ashley's argument was basically that you couldn't separate these rules. He claimed the board was a class of membership, so their attendance was absolutely essential. And to back this up, he pointed to Robert's Rules of Order, which is a famous guide for how to run meetings. But the HOA's defense? It was much simpler. They basically said, look, the bylaws never say we have to use Robert's rules, and it's crystal clear that Article III is for member meetings and Article V is for director meetings. Period. With two completely different takes on the same words, it was time for a referee. An administrative law judge had to step in to make the final call. And to do that, the judge had to apply some really fundamental legal principles. First up is this idea of the burden of proof. Think of it this way. Since Mr. Ashley was the one making the accusation, it was his job to prove it. The HOA didn't have to prove they were innocent. He had to prove they were guilty of breaking their own rules. And the level of proof he needed to meet was what's called a preponderance of the evidence. Now, this isn't like in a criminal trial where it's beyond a reasonable doubt. This just means the judge had to be convinced that Mr. Ashley's version was more than 50% likely to be true. It's all about tipping the scales, even if it's just a little bit. So how did the judge see it? Well, the decision really came down to a few key things. First, the judge said the rule for member meetings was perfectly clear. The legal term is unambiguous, and it simply never mentioned needing board members there. On top of that, Mr. Ashley couldn't show any proof that Robert's rules were part of the deal or that the board was some special membership class. So the conclusion was pretty straightforward. He didn't have the evidence. He hadn't met his burden of proof. And with that, the case was closed. The judge's order was direct and final. The homeowner's petition was dismissed. In the eyes of the law, the HOA won, and those meetings from 2017 and 2018 were declared perfectly valid. Now, even though this was a loss for Mr. Ashley, it offers some incredibly valuable lessons for anyone who lives in a community with an HOA, or really any situation that's governed by a set of rules. So what can we take away from all this? First, words matter a lot. If a contract is written clearly, that's exactly how a judge will read it, no looking for hidden meanings. Second, rules are specific. You can't just mix and match them. The rule for directors was only for directors. And finally, and this one is huge, proof is everything. Mr. Ashley had a theory for sure, but without evidence straight from the contract itself, it was just that, a theory. This entire legal battle, which went on for months, was all fought over a few sentences in a document that every single person in that community had a copy of. It's a powerful reminder that understanding the rules you've agreed to live by isn't just for lawyers, it's for all of us. So it makes you think, right? When was the last time you actually read yours?